Thank you so much to everybody for joining me today. My name is Cassidy Sai, and I'm the Marketing and Events Manager for the University of St Andrews Entrepreneurship Centre. And today we are joined by Christian Ziar, who is Head of Technology Transfer. Christian's going to talk today a little bit about intellectual property or IP awareness and why it's important in the commercialization process. So without further ado, I will hand over to Christian. And like I say, any questions do pop into chat. If you do have any technical difficulties at all, can't hear us, for example, at any point, just let me know and we'll be able to sort you out. But yeah, Christian, over to you.
Yeah, Cassidy, thanks so much, and thanks everyone for making the time to join this session. As Cassidy said, I'm more than happy to have questions. In fact, I'd encourage questions. I think intellectual property, whilst perhaps an interesting subject, is a relatively dry topic. I've tried to contextualize it and give it kind of relevance to a university setting, but I think questions and input would be invaluable to help the session come alive. Depending on the nature of the question, we'll either stop and pause to take the question, or alternatively, if it's a more general question, we'll leave it to the end and see how much time we have for sort of a Q&A session. So I'm sharing my screen. Hopefully everyone can see okay. So I just talk a little bit about my background and how I found myself at the university working in technology transfer and specialising in intellectual property. So I originally did a law degree. I then spent 10 years working at a private patent and trademark attorney firm. During that time, worked with quite a few startups, worked with some big blue chips as well, but also I think critical for me, really, I worked for 2 universities at that time, supporting their technology transfer, their licensing activities, which gave me a bit of an insight into this world, this realm of activity. I then spent about 3.5 years working at Arm, which is an IP licensing company based down or headquartered out of Cambridge. Arm, I think, is one of the UK's really sort of success stories. They don't really manufacture any products, so pretty much all they do is licensing of semiconductor computer chip designs, but they have about a 95-96% market share for mobile phone chips, which is pretty extraordinary for a company that's not overly well known. So it was a really great place to work and gave me a real insight into open source software, into IP licensing models. They also did quite a bit of contract research with universities, so again it gave me some insight into how those relationships worked. I then joined University of St Andrews back in 2019 to manage the university's IP portfolio as head of IP, and then sort of transitioned to managing the team that sits within, which is the technology transfer function. So that's a bit about me and my background. So tried to keep it relatively targeted today in terms of the session. So I thought we'd start with looking at what IP is, why it's important generally, but also in a sort of a university context. Then to look into the overview of the key strands of intellectual property, touch on ownership, touch on freedom to operate, and finally have a look at university commercialization, how that works, and the university's IP policy. So the starting point is to look at where IP fits within sort of tech transfer and commercialization, and this is relevant within companies as well. Typically we see it as this sort of cycle of activity where an idea is generated, whether it's through research, whether it's through R&D in a company, but at the stage that idea is generated and kind of crystallized, there is a disclosure, whether within a company or university context, and where we're looking at the commercialization journey. There's an important first few steps around assessing what that idea is, what the relevant intellectual property might be connected with that concept, and then looking at the protection of that. So that's where we are in terms of today's focus and journey. So what is intellectual property? So intellectual property is a bundle or collection of rights. Principally, it's patents or patents if you're in the US, trademarks, designs, copyright, and then finally sort of know-how and confidential information and trade secrets. And effectively, it's a bundle of rights that seek to protect innovative and creative ideas and the expression of those ideas. And as we'll come on to see, it's quite often the case that a concept that's been created, or a piece of work that's been created, is protected by multiple strands of intellectual property. So we'll dive in and have a look at what those strands of IP are, how they interrelate, and why they might be relevant in terms of your research, your studies, and your work. So I thought I'd start with Apple, a big user and exponent of IP, and just at a very simplistic level, I've put sort of Apple in the middle of this slide, and I've shown sort of the products that they have, just a subset of the branding which are protected by trademarks that they have down at the bottom. A hugely brand-led company. On the right, I've given an example of a patent application. Again, we'll dive into that in more detail. On the left, I've got some sort of 3D design protection, but this is really, I think, the tip of the iceberg. There'll be copyright in their design materials, their website. There'll be copyright in their software, etc. But even in one product, it's a good example of how there's multiple strands of IP at work. So why is IP important, generally speaking, and within a university context? So they can be extremely valuable assets. Certainly for companies, you'll often see for big companies that IP can make up a significant part of their value, and that's shown on the balance line in their returns. It enables differentiation between competitors. I mean, you see that in very brand-led areas, clothing, for example, sportswear, some areas of technology where actually the products are potentially quite similar from a technical perspective, but it's really the branding that separates them out and allows that differentiation. And it's the IP that legally underpins and requires that differentiation. Often used to attract investment. That can be a large company looking to secure further investment. It might be a startup, or it might be a project idea. The ideas and the innovation that underpin or attracting that investment will be a large part of the basis of the investment, but often you'll see that if the intellectual property isn't understood, isn't well explained, and or hasn't been protected, that investment won't proceed. For a company like Arm or for a university, we look to secure license revenue where we're commercializing bits of IP that come out of research, and IP is the mechanism through which we work with companies and look to secure that license revenue. For the university, we have a lot of external reporting obligations around knowledge exchange, around innovation, entrepreneurial activities, and intellectual property, how much intellectual property the university has, what it's doing with it, who it's licensing it to, what revenue it's obtaining from that activity. It makes up a whole realm of mandatory reporting that we have to engage in with funders and the government. Finally, in particularly research collaboration agreements, ownership of the IP and access to IP is absolutely critical, and it's one of the areas that is, I would say, discussed or negotiated in most detail. It's really critical that at the outset of any collaboration or any partnership that the parties agree and understand who will own the intellectual property, who will have access to it, and also to what extent the parties are able to use intellectual property that existed before any collaboration has started. So the first kind of bucket of intellectual property that we're going to look at is patents or patents, which is the IP right that the university has most formal registration for, and is our primary area of focus. We do work on other forms of IP, we do support other forms of IP commercialization, but patents are the large percentage of our activity. So a patent or patent is an official right for an invention. It provides a monopoly for a fixed and limited period of time, which is usually 20 years. And I think quite critically, it's important to understand what it gives is the right for the patent owner, the patent holder, to stop others from using that invention. It doesn't give you the right, quite critically, to make and sell or use your own invention. It stops third parties from being able to use that. It's granted in exchange for full public disclosure. So effectively, if you come up with something that's a technical idea, and this is perhaps less relevant in the university context where there's a kind of a default position of wishing to publish around significant research discoveries, but certainly in a corporate environment, you might decide not to publish, not to make publicly available. And if you pursue that route, then you can't obtain patent protection because it's absolutely an exchange of full disclosure of the technical process by which you are able to achieve that invention, how it works, technical diagrams, etc., in exchange for a request for that 20-year monopoly period. Point 4, as I've touched on, it doesn't confer a right to use. I think this is a common misconception. You may have a granted patent, but your product may still infringe. And in fact, I would say there's a lot of areas of commercial sales where it's common that if you have a patent, you make a product based on that patent, that you probably will infringe other parties' rights. We'll come on to talk about that a little bit later. Finally, patents are national rights, so a separate patent must be obtained in each country of interest, and you end up in a situation where you have a bundle of patents in different countries. And perhaps of interest to note is the scope of protection of those patents in different countries can often be quite markedly different. So just carrying on the point around if you have a patent, it doesn't necessarily allow you the right to use what you've invented or to make and sell it. I've taken out quite a simple example of a bicycle. And patent owner A, patent inventor A, has come up with the idea of a wheel. They filed a patent for a wheel and they've got that wheel patent granted. Separately, and this typically would be at a later stage, inventor or company B has come up with the idea of a bicycle, and they filed a patent for a bicycle. You end up in a situation where patent owner B or company B cannot make and sell the bicycle without infringing the patent for a wheel. And likewise, company A can't sell a bike, which is what they're likely to want to produce with their bicycle wheel that they've patented. So you end up in a situation that either company A has to license the rights to their patent to company B. Company B then goes and makes a bicycle and gives a proportion of that share back to company A, or alternatively they cross-license. So they say to each other, well, you can use my patent and I can use your patent. Maybe we'll exchange monies for this, or perhaps we'll just agree that you can use my patent and I can use yours, and that enables both of us to go out and make a bicycle. But I think the critical point is that company A cannot go on and create a bicycle without infringing the rights of company B, and company B can't make and sell their bicycle without infringing the rights of company A. But the patent office is quite happy to grant both patents, provided they've met the requisite requirements for a patent. They won't turn around and say, well, company B, you can't have a patent for this bicycle because the concept of a wheel has already been protected by an earlier company. There's a formal patent application process. I think one of the key things, the two key takeaways, I think, are that it takes time. It can take up to 5, 6, 7 years for a patent to be granted. It's very rare that it's less than 2 years. Something like 3 or 4 is often the typical time period. I've laid out the typical steps here. So you file a patent application, it's searched and it's examined by the patent office. The patent office will then say, we refuse your patent application because we found existing inventions disclosed which are too similar, or we don't think it's technically, it doesn't work, or you've not fully disclosed how to make it. So that leads to a refusal. I would say the vast majority of patents, 80, 90, 95% of patent applications reach such an initial refusal. But the key thing to take away is that the patent applicant is given multiple opportunities to amend the patent to resolve or overcome the issues. So in a simplistic example, when you apply for your patent, you generally try and claim a very broad and wide scope of protection, and then at each stage of amendment, you typically narrow that down in order to overcome the objections of the patent office, and hopefully that ultimately leads to a patent grant, which is the sort of the penultimate box in the process. And once you get your patent granted, then you need to pay an annual renewal fee to keep it in force for the up to 20 years that I mentioned previously. So that's the process. Patent requirements. There's four key ones. They're quite simple in many ways, but they are extremely challenging collectively to overcome, which is why it can take 5, 6, 7 years to get that patent granted. So the first point is a patentable idea needs to be novel. That means that there can't have been a public disclosure by anyone, including the patent applicant themselves, before the patent is filed. So if you've published on the 1st of January, you file your application on the 2nd of January, that patent will be null and void. You won't get it through to grant. Likewise, if a third party, has published something which is essentially the same technical innovation, again, that will bar your ability to secure a patent. The next step is it needs to be inventive, which in simple terms means not obvious. So you need to make a technical improvement or a technical enhancement, which is a non-obvious thing to do for someone who works in that technical field. So I don't know, to use a very simplistic example, if we go back to the bicycle, let's say a bicycle is known, a unicycle is known, and you come up with a concept of a three-wheeled bicycle, effectively in one line rather than a sort of a trike type setup. Although that's novel, that's new, the patent office are likely to turn around and say that's not inventive. It would have been an obvious thing to try a third wheel, given that 1 and 2 wheeled bicycles, unicycles and bicycles are known. I'd say in contrast, maybe the first tricycle where you have, say, a fixed rear axle that provides stability, etc. If that overcomes some technical issues and you were the first to do that, that's something that might be patentable. The third requirement is it needs to be capable of industrial application. Really, that means it needs to be something that's technical in nature, that can be reproduced in an industrial environment, and it's sort of the requirement that I guess puts in place the boundaries for what can be a patent, and is the reason that you can't get a patent for a business idea, or you can't get a patent for a work of art, which we'll come on to talk about, would be covered by copyright. And then the final point is it can't be excluded subject matter. So through public policy, there are a few areas in different jurisdictions which governments and legal lawmakers have decided shouldn't be patentable, that no one individual company should have exclusive rights on those. So in the EU, for example, methods of treatment of the human body is excluded from patentable subject matter. So a new pharmaceutical can be patented. A new scalpel or other medical device can be patented, but the kind of methodology and approach of using perhaps that said scalpel to conduct open heart surgery or brain surgery can't be patented, because there's a public policy need to keep that free for everyone to use for public benefit. So diving a little bit more into novelty and inventiveness. So as I said, there can't be a public disclosure, and that extends to the patent applicant themselves as well as third parties. The inventive step requirement is a little bit more complex, but effectively it boils down to really needing to find a technical problem that's overcome by your solution, your patent application, and the solution is likely to be considered inventive. Nothing is too simple to patent per se, but generally the more complex a concept is, and particularly if a problem has existed for quite a period of time, if you are then the person to come up with that solution, however complex or simplistic that solution is, there is a reasonable chance that that concept will be patentable. And the advice that I've generally seen given both in a university context and in a corporate context is do not underestimate the inventiveness of your ideas. I think I've had this conversation so many times with people who have gone on to be patent inventors that it seemed obvious to them to come up with their solution. It seemed like the obvious thing to do, and because of that, they think it's perhaps not worthy of patent protection. In a lot of instances, it is, and just because the solution came to you and seemed like the obvious and elegant next step does not mean that it wouldn't be able to proceed to a valid patent. I can't see any questions on patents, so I'll move on to the next strand of IP, which is designs and design rights. So again, this is kind of a bundle of rights that protect the 2D and 3D appearance of works of art, but also particularly products that they're encapsulated in. So as I've indicated on the slide, there can be 2D patterns, icons, logos, web pages, short animations apply to a product, or they can be 3D, which is perhaps a little bit more common and certainly the area that's protected more, and it will apply to products, parts, sets of products, or even something like a showroom layout. So going back to the Apple example, the Apple Store layout is protected by way of a design and stops someone from emulating something extremely similar to the Apple Store layout and colors, etc. But obviously things like the iPad are protected as a design, and Apple have had a lot of litigation in the courts with Samsung in the past, very publicly, around copying of effectively tablet designs, and a lot of it centered on how rounded your corners are and where your on-off button or interaction buttons are placed, etc. So there's unregistered and registered design rights. Understandably, or perhaps predictably, for registered designs, you need to file and submit a formal application. Unregistered design rights arise automatically, but only protect against copying. So the key differentiation really is that registered designs have a formal process required. You need to meet certain thresholds to get your design right granted. But having done so, it protects against any activity by a third party, whether intentional or otherwise, whether they've seen your design in either in the marketplace or your registered design right online. Whereas an unregistered design right, effectively, if a party develops something independently that ends up looking very similar to the concept that you've first created and published as a design right, the law will not, if they can demonstrate that they've not seen your work, your original design, they've created it independently, then if you've not registered your design, then there's no protection, and there's no right to ask them to stop using it. I think that the critical bit to understand is that design rights protect the look as opposed to the function of the design. So for example, you couldn't get, going back to the bicycle wheel example, you couldn't get a design right protection for a wheel because the function of that design is that it needs to be circular at the outer edge in order to work well. Something like a bicycle, to use the other earlier example, you could protect certain aspects of that. Again, you couldn't get protection which covered the shape of the wheels, but the bits of the bike where the shape is not required or is not the only technical solution, you could get protection for and would be able to stop a third party from making something that looked very similar to your particular bicycle. Moving on to trademarks, which is the next kind of bucket of IP. So these prevent or provide a right to prevent others from using an identical or confusingly similar trademark in relation to similar goods or services. So these really are the rights that stop people from using a similar company name, a similar product name, a similar a similar logo, a similar strap line, similar colors and get up for your product. Again, they're territorial in scope, and what that effectively means for all IP rights, whether a registered design, a granted patent, or a registered trademark, is if you have protection in, let's say, the UK, but you've not secured any protection in, let's say, the US, any party is free to use that same trademark, that same patented idea, or that same design in the US without infringing the rights in the UK. So the territorial nature really means that there's a few exceptions, but broadly speaking, you need to secure protection in the territories where it's critical that you wish to trade and you would want to be able to stop a third party from using a similar, in this case, logo. It's the one brand or the one bucket of intellectual property that can last in perpetuity. The only requirements are that you use the trademark and that you renew it typically every 10 years for a fee. So some of the earliest trademarks are now sort of 200, 250 years old and are still live and valid. All other forms of intellectual property, whether it's copyright, whether it's patents, whether it's design rights, will eventually expire. And you reach a point where you can't extend the protection any further. So the works of Shakespeare, for example, or Mozart's works are all out of copyright protection. There's no remaining IP protection, which means that you're entitled to make, sell, and resell those items. Trademarks, that isn't the case, and logically it makes sense. If a company or a product still exists, then it's appropriate that third parties are not able to use that branding or that logo whilst that product or company still exists. So a trademark is any sign capable of distinguishing goods or services of one undertaking from those of another. Effectively, it means that if a consumer views whatever is being asked for protection under a trademark rights as a way of being able to tell the goods or services of a particular company, then it should, in theory, be capable of being a trademark. There's some exclusions, so it needs to be distinctive, or it can't be non-distinctive. It can't be descriptive, and it can't be customary or widely used in the trade. So you can't go to the trademark office and say, I want to file for mobile phone as a trademark because I can see no one else has applied to secure that. So I'd like to have a monopoly and be the only party who's able to use that. That's a term that's both descriptive and customary in that area of operation. It's probably not distinctive as well. So the trademark office will turn around and say, well, no, yes, we accept no one else has ever applied for that, but you can't have that. Sticking with trademarks a little bit more, so the fact that it can be a sign has expanded in recent years. It used to be that trademarks really just protected a logo or a word, a company name, but the law has recognized in recent years that there are other ways that we can tell one company or one company's offering from another. So in recent years, the sort of scope of protection has expanded to include musical jingles, for example, the Intel Inside jingle. It's colors, so a single color, for example, Cadbury have been successful in some countries in securing their kind of distinctive purple coloring without inclusion of the word or inclusion of any other colors. Likewise, EE, who used to be orange, had a very distinctive orange color to start with, and they applied for and managed to get protection for that particular tone of orange, that Pantone color or that RAL code for use with telecommunications. There's also been acceptance that smell, for example, could be registered as a trademark. One of the earliest cases was the scent or smell of freshly cut grass for use with laundry detergents. That was accepted as being capable of being a trademark. So really any way that you can tell a product or service offering from one company to another is likely to be capable of trademark registration. Moving on to copyright. So copyright provides protection for really quite a wide set of creative rights. So it's original literary, dramatic, musical works, artistic works, sound recordings, films, broadcasts, and databases. So you typically find that copyright will protect software, it will protect drawings, it will protect journal publications, films, animations, the content on a website, instruction manuals, marketing literature, advertisements. Really, the only requirement for copyright is that it's an original work and that a reasonable degree of creative energy has gone into creating that work. So generally, you would find that a literary work of, let's say, 3 words, which typically might be a strapline, for example, for a company logo, or just a combination of 3 words, might not be sufficient to activate copyright protection. But certainly something that you write that's a page, a couple of pages, absolutely would be. And as I say, it would also protect software, for example. And again, it's the expression of the code in the software rather than the technical function of the software or the visual appearance of the software or what the software is doing. But the actual underpinning code would be protected by copyright. There's no requirement to register copyright. It arises automatically as soon as you create the work. You have a degree of protection, and really once you make it publicly available, then you have full copyright protection in that work. Similar to unregistered design rights, though, if you wanted to stop a third party from using something that you felt infringed your copyright work, you would have to demonstrate that that third party had copied the work. Clearly, where it's an exact kind of verbatim copy, then you wouldn't have any difficulty doing that. But if with software, for example, if you felt that maybe part of your code had been taken and used for another piece of software, but that software code wasn't exposed when it's used, you would face an uphill struggle in trying to claim that your copyright had been infringed. There are certain jurisdictions which allow registration of copyright, so you can formally register your copyright work. It's relatively inexpensive and it's relatively quick. The 2 reasons that parties would typically do it are, first of all, it gives a much more definite date of creation and proof that you created a work on a certain date, or certainly submitted it to the Copyright or Patent Office on that date. The other reason, places like the US, which are quite keen on or are quite popular jurisdictions for litigation to take place, it opens up a broader set of remedies if you've registered the copyright versus if it's unregistered. But the key takeaway is it arises automatically, and the law recognises there is a need to protect people's creative expressions, which is what copyright does. Ownership of IP, absolutely critical in a university setting. It's probably what I spend more time, I think, looking at ownership of IP than I do kind of assessing whether the IP can be protected. It's very often complicated in terms of the funding that was provided for the work that created IP. It's not uncommon that we've collaborated with third parties, that perhaps some of the work was done at a previous institution, a previous workplace, and it's quite a challenging thing to unpick. But it's absolutely critical in order to both protect that IP. You need to understand whether you are, as an applicant, as a party, entitled. You own that IP and are therefore entitled to protect it. For the likes of patents, for example, there is a requirement that you set out who all the inventors are, which often is not straightforward, and trying to understand who's provided a contribution to a technical innovation or a eureka moment can be very, very difficult, and it's difficult to separate out perhaps those who have reduced it to practice or have produced data that supports the idea. Have they contributed to that technical innovation or not? And that is quite a complex process. And the final bit around ownership, are there obligations to report the creation and or filing of IP? So I face this on a regular basis in relation to Scottish Government, for example, but also Wellcome Trust, British Heart Foundation, various funders who provide the university with research funding. They require us to submit an annual return. I think the US military is another one where we have to state categorically and provide a nil return, even if we haven't had anything, whether that research has given rise to any intellectual property, and whether any has been disclosed to the university and whether we've protected any. And then at a later point, they want to know if we've commercialized any, and they want to know, what monies have been, what revenue has been generated by that activity. And certainly in respect of some funders, increasingly, Wellcome Trust is a good example, they're now increasingly asking for a share of that commercial revenue. And it's understandable, I think, from a funder perspective, they want to be able to demonstrate that their funding is having a real impact, and they, as a sort of a cycle of activity, increasingly their justification is that they would like a share of the commercial outcome of that piece of research, if there is any, so that they can reinvest it into future research funding. Freedom to operate is probably something I've touched on a little bit with my bicycle example, but I thought I'd talk a little bit more about it. I think it's a common pitfall. I think people are often very focused, particularly in a commercial settings. I think particularly relevant for sort of a corporate setting where you're creating a product and you're very, very focused on, do you have all the permissions that you need, perhaps from employees, from people you might have subcontracted bits of the work to. Have you protected it by way of a patent? Have you got design right protection? Have you maybe got copyright in the underpinning code for, let's say, this piece of software on a technical device? I think less attention is given to are there any third-party patents, designs, trademarks, or copyright which might prevent you from using it? For example, have you used some open source software, which the terms of the open source software license are that it can't be used for commercial use, for example. That comes up quite often. You may have filed a patent, going back to the bicycle and the wheel example, but that doesn't mean that as the patent owner of the bicycle that you're not infringing an earlier patent and the rights of a third party who might own the wheel, who might own a patent to a chain, a patent to a gearing configuration, etc. And often, particularly for smaller companies, and you see big companies fall foul of this sometimes as well, the first time that they really look at third-party rights is when someone comes knocking on the door and says that we've already got a patent here, or your brand or your logo or your company name is too similar to ours. There's going to be confusion in the marketplace. Here's a letter from our lawyers saying that you need to cease immediately, and you also need to either pay us a large amount in damages, or you need to give us a share of the profits that you've obtained from this. It's far better if at the outset, whether you're looking to start a startup company, whether you're looking to work with industry and let them then take on and develop a product into the marketplace, it's far better to at least do some element of searching to understand what third-party issues there might be, because it might be at quite an early stage. You have to conclude that you aren't going to be able to work around the third-party issues, or indeed, in product development, certainly again in a commercial setting, you decide at quite an early stage that the solution you wanted to work on isn't available, and you choose an alternative and you find a workaround for the third-party rights. So it's critical to identify and understand any problems early to determine a solution. You want to understand the potential risk. You want to either design around the IP that exists. You could, if you wanted to, in a corporate setting, typically attack the validity of third-party IP. So perhaps you've already published in this area, you've already disclosed this idea, and you haven't looked to secure a patent, but you now want to develop a product or launch a company to develop a product there, and the third party's got a patent. You have the opportunity to go to the patent office and say, I'm sure it was unintentional, but when you did your searching to establish whether this idea was novel and or inventive, you clearly seem to have overlooked the fact that 2 years prior to that application, I published an extensive journal article on the concept of this idea, how to make it, how to develop it, and if you had seen that, clearly you wouldn't have given this company a patent. So that's a common approach. The alternative, going again back to the bicycle and wheel example, is you can seek an appropriate license. So if one company has got a patent or other IP right that's blocking your route forward, you can go to them and say, can I have the right to use your IP so that I don't infringe? That might require a single upfront payment, or it might, you might have to agree to share some of the proceeds from your future profits with that company. But it's a common way to work around challenges. And certainly in the software and hardware space that I used to work in, it was extremely common for companies to cross-license to each other hundreds and hundreds of patents to enable them to make and sell their products. So Intel, Apple, AMD, all these companies, without permission and giving permission to each other, pretty much all of their product stack would not be able to be sold in the marketplace. So I think that's my second to last slide. So I revisit a little bit what we do in sort of knowledge exchange and tech transfer, so talk about the IP and commercialization journey. So I suppose in the technology transfer office, we support, I suppose, or work with a very small, I suppose, subset of research outputs. So there's a lot of research which could be capable of IP protection, and it could be capable of commercial development, but there's no requirement that idea is disclosed to us, and there's no requirement that we work to move it into a product. It's understood that one of the key drivers for research is around publication, and that often there isn't a desire to pursue commercialization, and that the best path to securing impact from that research output is not through commercialization. It's through making that innovation or that work open to all, open access, open source, and we absolutely support that and understand that. So we work with a small subset of concepts. As I've said previously, a lot of these are patentable in nature, but we do also, we support quite a lot of know-how, we support software development, and we support some broader innovation as well, where there is a desire to seek a commercial outcome. We will capture that idea by means of a disclosure form, and then we'll conduct due diligence, which for us is really looking at the earlier point of, do we own the IP? Are there obvious barriers to progressing that IP to a commercial outcome? And assuming that we don't encounter any significant obstacles, we'll then look to undertake commercialization assessment. So just because an idea is innovative, just because an idea is capable of intellectual property protection, does not mean that it automatically has commercial value. It may be that there's not an applicable market for it. It may be that it's a much better way of, I don't know, let's say producing a chemical, or a much better way of treating wastewater from a technical perspective. But if it's prohibitively expensive that it could never be adopted by the market, unfortunately, it's unlikely to have commercial value or commercial merit. But for those projects that do, we work then closely with the innovators, academics and or students to support the commercialisation activity. The university leads on that, but it's very much a collaborative process. The university recognises that we need the technical input, the technical support from those who were the originators of the idea. And then as a recognition of that, any revenue that then stems from the commercialization of that particular idea or that piece of research is then shared three ways. With the school, the university takes a share, but the originators, the creators of or inventors of the work also get a share of that revenue. For in terms of the inventors or innovators share, for staff, that those monies can be used either into a wire account for further research activity, or can be paid directly as part of payroll. And we disperse quite a significant amount of monies each year to both innovators, but also to the schools that the ideas came from originally. Happy to move on to any questions, and I think one's just appeared in the chat, so I'm happy to take that first. But otherwise, that's really all I had on IP. So more than happy to answer any questions either about the specific areas of IP and how they work, or alternatively, I'm happy to talk about I suppose either IP in a commercial setting or IP at the university and knowledge exchange, if there's any questions around that. So the first question is, does the innovation need to be in a final version prior to disclosure to your team? It's a really good question. I think the very simple answer is no, it doesn't need to be. Certainly I would say for us to assess it, and if it were to be something that's inventive and technical and capable of, or potentially capable of, patent protection, it needs to be, I would say, crystallized into to the extent that it can be demonstrated that the idea works. So the law won't protect the concept of a technical innovation, the concept of a book idea, the concept of some software. What the law does is protects the particular expression of that idea, which really means that for us as a team, that you need to have reached a point, let's say it's a technical innovation, that you need to have reached a point that you've convinced yourself that it works, and you've seen how it works, and you have data to support that it works. If it's a copyright work, you need to have a sort of a draft or final manuscript for us to look at. Likewise, software, it might be an early sort of beta version. That's absolutely fine, but the law won't support, and it's difficult for us to support someone who comes in and says, well, I want support with the idea of creating a software program that does X, Y, Z. We can give some initial pointers, but we're not going to be able to, until it's crystallized into something tangible, we're not going to be able to sort of support taking that forward as a commercial prospect. Happy to pause there. Happy to take any more questions. Yep. What are the proportions of revenue split three ways? Sure. So they're all available in our intellectual property policy, which is it's on the university website in the governance zone. It's also, if you just use Google or similar search engine and put in St Andrews IP policy, it should pop up. So it's publicly available, publicly facing. It is, so there's tiers of revenue split, which means that initially the innovators get far more than 50%, but as the revenue increases, that split changes to become closer to a third, and as it goes, if it makes, let's say more than $1 million or more than 2 million, the school and university start to get a slightly larger share, but it's been designed to try and make sure that there's a larger reward for a broader spectrum of revenue commercialization. So yeah, so it's there, so it's publicly available. And I think the second question was, how might these proportions change depending on the innovator, undergrad versus masters versus PhD versus staff? Yeah, absolutely. So So I think this builds upon the topic of IP ownership. So by default, students own the IP that they generate when they're at the university. There are some exceptions to that, which again are dealt with in the IP policy. Most of those come from or are necessitated by funding. So certainly for postgrads. So if the funding requires that the university owns the IP, or the funding requires that the funder, let's say it's an industry PhD or industry placement, owns the IP, then the university needs to take ownership in order to then pass that on to the company as funder. So where the university doesn't own the IP, effectively we offer to the creator of that IP that if they would like to work with the university and would like us to lead commercialization in the same way as we do for university-owned IP, that we'll do that. And then if that is what is agreed, and that's the route that's preferred, and all parties agree to that, then students are treated exactly the same as staff in terms of percentage share of revenue. So there's no differentiation depending on whether you're staff or whether you're say a postgrad student, or whether you're professional staff versus academic staff. Effectively, if the university either owns it or it's decided that and agreed that the university will lead it, as if it was originally owned by the university, that the distribution of revenue will be the same, irrespective of the person. And where this often actually comes out more often than that sort of binary example or delineated example I've given, is where we have contributions to an invention that perhaps there's one student and two staff members. Again, it only works if all parties agree who's going to lead the commercialization activity, but also I think it's only fair that everyone should be recompensed in the same way. I'm just scrolling back up to the questions. Yeah, how are design trademark infringements judged, as most of them seem very subjective? For example, product design of a car. Yeah, really good question. I could happily talk for hours about this. I'm sure no one else would be particularly interested for hours, but I'll try and give a succinct example. So they're different. So what constitutes infringement and the basis for assessing infringement is different for all of the different IP rights. So for trademarks, it's pretty simply or the basis of approaching it is pretty simple, in that would a typical consumer of those goods and services be confused between the two differing brands? So I think a year or two ago there was sort of the Colin the Caterpillar and the Lidl and M&S spat. And the question was, would the typical consumer be confused by the two? It depends on how that's assessed, depends on the sort of product or service. If it's a supermarket good, it's, walking down the cereal aisle, you see, I don't know, Kellogg's cornflakes, and you see another cornflake offering, which is that similar sort of yellow and colouring, and perhaps it's called, I don't know, Kettogs rather than Kellogg's. If a reasonable number of consumers are likely to be confused between the two, then you're very likely to get a finding of infringement. Design rights are a bit more technical. You effectively you have to try and identify which are the key differentiating features. So to go back to my kind of iPad tablet case I talked about earlier, tablets are by necessity flat, by necessity a large percentage of the frontal section is going to be screen. So it's really where there's design freedom. The curvature of the corners, the placing of the home button, speaker placement and size, etc. So that's a more technical assessment. But really, it's would a typical consumer think that the two products look similar? Does it remind them of the earlier one, or is it just enough that it brings the earlier one to mind, and they think, well, they're quite similar, but I think that they're likely to be different. The law is, in most instances, it's based on how a typical consumer would interpret the goods that they're interacting with. And if you remove the branding, if they think, oh, this tablet I've just picked up is very likely to be an Apple product because of these technical and visual appearances, and it turns out that it's a Samsung tablet, that's where the courts will likely find infringement. And in certain cases, they'll do a market survey, they'll do polls, they'll bring in technical experts. So there's quite a well-established process. There are definitely some cases that are in that grey area where no one can really determine exactly what decision will be reached. But for where it's more clear-cut, there is a very defined process that courts follow, and it's quite well harmonised internationally, I would say. Next question: how often does St. Innovation get involved with IP for free and open source software ideas? So I'd say St. Andrews Innovation broadly, I would say gets involved quite often. If and that's across the team. So it might be that you've got an open source software idea, but you're looking to build a startup company to offer a service in support of that software that you've so you've made the software freely available, but you're offering effectively a support service to work with that. I mean, you see that in open source software like Red Hat, for example, which the software is freely available, but the service and support that they offer with it is bundled in a way that it's revenue generating. So we can absolutely support there. Where you simply want some advice and a steer in terms of, let's say you wanted to make it open source, but you wanted perhaps some advice on whether that was the best thing to do, and if so, what flavor of open source license is best suited for your particular piece of software. Yeah, I'm more than happy to give any preliminary advice there. We won't go as far as being the party to put it on GitHub or whatever and actually manage the life cycle of that open source software, but we can absolutely give you some pointers. Is it possible to secure copyright protection for research ideas such as PhD proposals or research project ideas? Not the idea per se. So copyright protects the expression of the idea rather than the concept. So to use a more simplistic example, something like the Harry Potter book series, the copyright protects the book, the written word, and how those words are expressed. There's really no protection for it. Doesn't stop someone else from coming along 3 months later and saying, oh, I like the idea of a wizard school and plotting the journey or tracking the journey of a group of children moving through that world, provided you don't use the same names, you don't use you don't lift copies of or portions of the text, you're absolutely allowed to create that work. So if you formalize a PhD proposal or a research idea, and when I say formalize, you put it into a summary, a written summary, that is likely to be a copyright work itself, which someone else cannot copy. But if it contains the idea of a research proposal, and then a third party, whether they see that or don't see it, 6 months later happens to start working on a piece of research which is broadly the same or even the same as that idea, copyright itself is not going to protect you there. Next question: what are the benefits to the inventor of the university leading commercialization by agreement? So if it's by agreement, so I guess this would be in a situation where the university by default doesn't own the intellectual property. The benefits will depend. There are case by case circumstance, but the type of benefits will be if that person feels like they're not best placed, they perhaps you don't know much about patenting, for example. You don't know a patent firm, you wouldn't know how to go about securing a patent. Yes, you could go to an external expert, or alternatively the university could manage that process and can manage that and will pay for that as part of its activities. Alternatively, you might be happy to navigate, let's say, the patenting process, but you don't have any links with companies who might take on the idea and take it to market. Again, that's something that university more often does, has a process of doing that, is comfortable putting in place license agreements between the university and a company. But it's absolutely worth considering on a case by case basis. I'm conscious of time here.
Are you happy to answer the last few questions, Christian, or would you rather we address them over email?
No, if people need to drop off, that's absolutely fine. I'll give each one, the final three, a quick short answer, and can always follow up if you have further questions. So if you have a protein sequence, can we outright patent a protein sequence or more patent of application? It depends. That there are circumstances through which you can patent a sequence, patent a protein, but there are some challenges around it. It would be very much a case-by-case analysis. How does St Andrews Innovation support PhD student-led projects? I'd say there's a broad range of support. If we don't own the IP, and a student wants to come and work with St Andrews Innovation, we'll support you with, if you're interested in company formation, if you're interested in exploring potentially licensing it to a third party, again, we're happy to support that. I think my general advice would be come and have a chat with us. We'll see if we can help, and we'll see if our help is the right thing for you. And if it's not, you can, assuming we don't own the intellectual property, you can absolutely go away and follow a different path. And final one I'll take is the one on open source code, developed by a research group at the university, and then used the code to design a product. Does the research group have any IP rights over the product which was designed? So I would say open source code, open source software, it very much depends on the flavor of open source license selected when that's made available. Some open source licenses have attribution requirements. Some say that you can use for anything but commercial use. It very much depends on the open source license. So the starting point would be to look at on what basis, whether it's from the university or whether it's from a third party, on what basis has it been made open source. I think open source is one of the areas where actually the legal complexity is kept to a minimum, and I'd say that for most people they're reasonably okay to interpret. They're generally very clear about what you are and aren't allowed to do with that piece of code. So that would be the starting point. Certainly with the university, if that open source license doesn't give you the requirement, the ability to use it in the way that you would like to use it, the nice thing about being within the university is you can approach the individual or the team that made that open source and said, well, look, could we have a less restrictive open source license to use it for this use? And those sorts of conversations, I think, happen relatively frequently, so that's something that could be explored. I am going to pause there in interest of time. More than happy for you to follow up either with me or with Cassidy with any particular questions, and we can look to resolve those. But I hope it was interesting. As I said at the outset, it's a slightly dry and complex subject, but the application of intellectual property, I think, is far more interesting, and I think the questions really have borne that out. That it's how does it work for us? How does it impact us? That really are the key questions. And myself and all of the SI teams, so Cassidy and Bonnie, I think the answer to a lot of these questions is come and talk to us. We'll see if we can help. We'll see if we can point you in the right direction. It may be in some cases that we'll end up leading that activity. It may be in other cases we end up supporting you, but we're here. We're happy to support. That's why we're running this session. So by all means, get in touch. More than happy to work with you.
Yep, thank you to everyone who joined. We will be following up with an email afterwards with some slides and contact details. So if you do want to reach out to Christian and the rest of the team, or as Christian mentioned, anyone else in SI, we're more than happy to help. But thank you to Christian. We'll let everybody go now. We are slightly over, but that's great. But thank you again for everyone's involvement, and enjoy the rest of your day.